Hi, warriors. This is Jaylyn, my legal warrior, and today's segment is going to be about moving away during the COVID-19, or as we all know it as coronavirus epidemic. Right now, there is still the stay-at-home order in place. And if you're in a situation where you do not have custody and visitation orders and you're trying to move away, well, good news for you is that there is nothing to prevent you from doing that because there are no child custody and visitation orders, right? But what that also means is that there must not be any filings for child custody and visitation. So that includes a divorce matter, that also includes a paternity matter. So any matter that involves your children, and if they're part of it, and that has not been filed yet, but you were intending on filing it, but now the courts are closed. And since the courts are closed, you just want to go ahead and move away from the state of California or the county of San Diego, and the other party does not consent to it, but you are the primary parent. And there's really not much that the other parent can do because the courthouse is closed, right? But remember, if you're on the other end of this and the other parent is threatening or is saying that they are moving from San Diego County without your knowledge or consent, and there's nothing like a court order, like a temporary restraining order, for example, that automatically goes into place when you file a brand new petition for divorce or paternity action, when you don't have that in place, you can file an emergency request. In fact, it would be of my professional opinion that is in fact an emergency. If you do not have a case already established with the San Diego Superior Court, our advice is that you do in fact file a petition to establish the paternity action or the divorce action or a petition for custody and visitation, whatever it might be, to establish that new case. And you also file your emergency paperwork. And there is a video where we talk about the process to establish or to set up a emergency hearing. So that would be an emergency because essentially your child is being removed without your knowledge or consent, and this would disrupt your continuity and relationship with the children or child. So take that into consideration if the other party is in fact trying to move away with the children during COVID-19 and you're not in agreement with that. Now, if you are a parent that does in fact have child custody and visitation orders and you do want to move during COVID-19, and there's not going to be any hearings on this anytime soon since the court is closed for that non-emergency matter, then you can't move, okay? You can't just pick up and leave. You'd be in violation of your current custody orders, and the other party can in fact file a contempt action against you. They can hold you accountable for violating the child custody and visitation orders if you decide to pick up and leave. So without the consent, the agreement of the other party, the other spouse or the other parent, you can't move. So if you are thinking that through COVID-19, you are probably not going to be able to maintain a life with your children in California, you've been financially impacted in a negative manner, and the support that you might be receiving is so nominal that you just can't keep your head above water. You need to go move in with the paternal or maternal grandparents at this point to make sure that your children have a roof over their head and clothes on their back and you have mouths to feed. And the only way to do that is by living outside of San Diego County, and the other party is not in agreement with that, but doesn't also want to help you financially to maintain the lifestyle here in San Diego. So if that's a situation that you are in, then you should start preparing for your move away request, because the way that we see it is that the economy is going to take some time to pick up, and even once things gradually start opening up, you might still need to move, because jobs are not going to be as readily available, because a lot of them are filing for bankruptcy, or they're not getting qualified for business loans. There might not be enough funds available to, in fact, rehire you at whatever job that you're in, or whatever job you were in. So if you're, again, at a point where I am going to have to move after COVID-19 is said and done, and I need to just go someplace that's cheaper, what is it that I need to establish for the court to understand why I need to move to a cheaper place where I can, in fact, still support my children and support myself, especially since the other parent is not supportive to the extent that would allow me to continue having a life here in San Diego County. So there are factors that the court must look at, and those factors stem from this case called La Mouche. So here are these factors. The reason for the move. Why do you want to move? And the court really wants to know whether the reason why you're moving is not because you want to alienate your children from the other parent. So if it has nothing to do with alienation, then this reason for your proposed move is going to be valid. Now, the child's interest in stability and continuity in the custodial arrangement. So how often have we modified child custody and visitation? What is the current schedule? Can we continue the current schedule with your move, or can we modify the existing court orders where it would still allow for stability and continuity? Because the court doesn't want you to move and then, a few months later, come back or do another move, and you're disrupting the stability of the children in their environment, as well as for the other parent. So the court wants to ensure that the stability and the continuity in the custodial arrangement can continue, that this relationship can continue in a way where visitation is still the same, or at least similar, so that the children do have a relationship with the non-custodial parent, the parent that's not moving. And then the distance of the move. So if you're, going from San Diego County to Riverside County, I mean, that's not a huge distance. It's probably not going to make a huge shift in your current custody and visitation orders. Again, depending on where the other spouse or other parent lives, the distance, can be a huge factor. But if it's, just a county over, then the court will, of course, take that into consideration. And it might not be a heavily weighted factor, but it's certainly a factor that the court must consider. And then the age of the child. So if the child is 2 months old, for example, that relationship is still being built with both parents, right? And more likely than not, the child is possibly more bonded with the mom, because she might still be breastfeeding and things like that. So you have to look at the age of the child. If this is a 17-year-old child and they're about to graduate, high school, the court is going to also look into that as well, and whether that's an appropriate time for the child to in fact move in the middle of their school year, the last year of school. And then the relationship with both parents. So if the child's relationship with both parents is equally as strong as the other, then that's going to be very difficult on the child. And how will the child be impacted by the move if he or she had to leave the other parent and move somewhere else? The court needs to look at that. What is that relationship like with each parent? And if you both are on equal footing, that's going to be a very difficult decision for the judge, which is why there's those 7 factors the court has to weigh in order to decide whether to grant you your request to move away from San Diego County. And then the relationship between the parents. If you have a hostile relationship between the parents and there is some history of alienation or domestic violence between the parents or the children, that's going to be heavily considered in your matter to move away from San Diego County. And so with that being said, you do want to make sure that you do have a decent relationship with the other party. It doesn't have to be fantastic, but it has to be decent in the sense that you guys are able to effectively communicate and it is not very hostile to the point where the children are being prevented from exercising their current visitation orders with the other parent or the non-custodial parent. So this is a heavily weighted factor as well in order for the court to grant you your request for a move away. And then the wishes of the children. In an example of a 2-month-old, there's no wishes, right? I mean, this factor is moot because the court can't take the wishes of a 2-month-old. But a 17-year-old, the court will take in their desire because they are of an age that they are able to voice an opinion as to whether they want to move or not. So family court services mediation, which is a requirement for a move away matter, they would in fact interview the child or children, at least the 17-year-old or the ones that actually can form an intellectual opinion about whether they want to move or not. So this is a very important factor as well. And then the extent to which the parents currently are sharing custody. So if you are 50-50, if that's you have a 50-50 arrangement where it's 1 week with one parent, or you guys have a 2-2-5 schedule, something along those lines, it's going to be an uphill battle to move with your children because you and the other parent are on equal playing fields at that point. And if the children are equally bonded with the two of you with this 50-50 custody arrangement, and the relationship between the children and the parent are also equal, and the distance of the move is so far, so great that it is going to disrupt the stability and continuity in the custodial arrangement, that is going to be a hard decision for the court. It's going to be very difficult because it's like everything is equal and all it's going to take is one argument, 1 point to deny your request to move away or to grant your request to move away. So if everything's equal, then you should really consider hiring a custody evaluator or having a custody evaluator on your matter, maybe even an attorney for the children so that he or she can help voice the concern of the child, especially in a highly contentious case where there is still, joint custody. So these are the factors that the court is going to review and will weigh in order for it to consider your request to move away outside of San Diego County, or really any county within California. It's really going to be dependent on the judge's discretion and what the judge believes to be in the best interest of the children, and whether the move, especially if you already have a child custody and visitation order in place, whether this move is detrimental to the children. And that's very hard to prove, that a move is going to be detrimental to the children, unless there is a long history of alienation and bad behavior from the custodial parent that's trying to move, or the non-custodial parent that's trying to move with the kids. The court is going to have a hard time making that decision to deny or grant your request to move away with the children. And with that being said, we hope that our warriors do in fact share our video. You never know who might actually benefit from this information, just to get them thinking about what their life could be like after COVID-19 is said and done, or at least as the stay-at-home order is lifted in the next couple of weeks or even months, but something to think about moving forward during COVID-19, especially since, California being a very expensive place to live, and you don't have a job or your hours were cut, and how will you, survive in for the rest of the year, not even just temporarily, but for the rest of the year. And perhaps this is the best time to consider a move away. And you could always mediate your request to move away if you wanted to move during COVID-19 right now, and you could go ahead and ask the other party to mediate with you. So I'm assuming if you're the other party, your answer is going to be absolutely not. I am not going to agree, and only a court order would I cooperate in a move away with my child. In a situation like that, there's nothing that you can do, especially if you have a court order in place and you do not want to be in contempt. So it's not an emergency for you to move with the kids, because if you can give the kids to the other parent while you move and set yourself up, then the court's going to find that to be reasonable as well. So if you go for a visit, like a temporary visit, and you and the other parent have an arrangement so that the other parent does in fact see the children in line with your custody arrangement, or the timeshare percentage between the two of you doesn't exactly change by you temporarily going somewhere with the children for a little bit, then that's okay. Remember that you should not violate your current court orders, and that the other parent has just of a right as you do to exercise their custody and visitation arrangement. And just because you are in this situation that is not financially beneficial right now, doesn't give you the right to move away without the other parent's agreement. Thank you, warriors, for watching my segment about a move away request, and we hope that you are staying safe during COVID-19, and please subscribe to my channel. Thank you.